Well, let's get started. Let me give you an overview of what we're going to cover today. First and foremost, I'm going to briefly talk about the various forces that have led us to where we are today, legal, social, and economic factors that have really caused the FTC to take the action that it has, or at least it believes it has to take. The second thing we're going to do is obviously go over the rule and its specifics so that you have a working understanding of what the rule covers, what it doesn't cover. As you may know, the U.S. Chamber of Commerce has filed litigation challenging the enforcement of the rule. Chris is going to take the lead on talking a little bit about that, and we'll handicap that proceeding and the impact it'll have on whether the rule will survive. And then finally, in the meantime, we're going to talk about what employers and business owners should be doing in light of the rules announcement, in light of the litigation that's pending, and some good practical steps that everyone should be doing when it comes to the restrictive covenants and protecting their trade secrets. So let's begin with talking about how we got here. From my vantage point, I think from the vantage point of many people, Chris, it all comes back to the Jimmy John's case. I think it was in 2015, Jimmy John's had decided to impose restrictive covenants and non-competes on its workers. Guys delivering the sandwiches, making the sandwiches, and it was something that caused a real sense of outrage throughout the country. A class action was filed. The Illinois Attorney General got involved, and eventually Jimmy John's stepped back, I should say, and stopped using the non-competes. But that seemed to provide a crystallizing moment, if you will, in the area of non-competes, and it began to generate a fair amount of attention, both on the state and federal level, on addressing these situations where lower wage employees might be subject to non-competes. And there's been a number of federal bills, none of which have been able to get off the ground. I'm just listing them all here. Many of them have been reintroduced primarily by Senators Warren, Senators Coons, Chris Murphy out of Connecticut. I think maybe even Sheldon Whitehouse may have co-sponsored some of these bills. They haven't received strong bipartisan support, although Senator Rubio out of Florida introduced one of the bills that was focused on non-competes involving low-wage workers. But the long and the short of it is, on the federal level at least, nothing's been able to get off the ground. On the state side, as some of you may be aware, there has been a fair amount of momentum with non-compete legislation. Minnesota last year passed a ban on non-competes with some exceptions. New York got so far as to propose a ban that Governor Hochul vetoed at the last minute. Chris, any thoughts on what you've been seeing in terms of those legislative developments, or sort of those forces that are creating these headwinds with non-competes?
Yeah, so the Jimmy John's case is really the canary in the coal mine,
yep.
And it grabs the national attention, much like the McDonald's hot coffee case and the tort reform.
That's a good
movement.
metaphor.
And so it also used as a rhetorical device, and what you see is there's absolutely incremental change happening across the country, with the most common theme being a wage threshold over non-competes. It's just an easy place for legislators to draw a line in the sand, and a lot of times you're seeing it right around the $100,000 mark. And both of us, I'm sure, assume that that's going to continue to happen around the country. What is a little more unprecedented is what the FTC has done when stepped in. And
it's been traditionally an area that states themselves have regulated, and as many of you are probably aware, there's a wide range of different approaches with these types of agreements. California, Oklahoma, they ban them outright. They don't want them to be used. Other states like Ohio, Pennsylvania, Michigan use them in a manner which courts are empowered to reform or modify the agreements to try and balance the rights of the employee and protect the legitimate business interests of the employer. So it's traditionally been an area of state concern over the course of the last 100, 150 years. Let me talk about some other things that have been percolating and creating, again, these headwinds that I described a moment ago. Obviously, there's been a fair amount of academic criticism. While there is some that would support the use of non-competes, it's probably a fair statement to say most of it has been academic criticism of non-competes, focusing on the impact on employee mobility, the stifling of wages, things of that nature, and that has served with some of the federal and state legislation to create this dynamic or this force that we're now seeing. The other issue, and this impacts us as trade secret lawyers, is non-disclosure agreements. They've been sort of lumped in the wake of the Me Too movement, the misuse of non-disclosure agreements to prevent people from speaking of issues of public concern, have sort of been thrown into this same conversation about agreements being used from employees that limit their ability to communicate or to earn a living.
Yeah, and I think wrongly lumped in.
I agree.
Because at the end of the day, if the non-competes fall by the wayside, you have to be able to drill down and protect confidentiality. So to say that stopping an employee from talking about the details of their employment is the same as stopping them from talking about an assault is obviously not the same thing.
Right.
And it's concerning. And this is the problem that we see writ large in the national landscape, is that there's such strong rhetoric that sometimes it becomes problematic from a standpoint of what do we do, boots on the ground,
Right.
day to day, to protect
Right.
our clients.
Right, that polarization we see on a daily basis in virtually every facet of our life is spilling over into this area as well. Well, the forces we've been talking about led to an executive order that President Biden issued shortly after entering office. In July of 2021, he issued an executive order that was fairly robust and comprehensive, that addressed a number of issues relating to unfair competition, antitrust issues, things of that concern. And within that executive order was a directive to the FTC that it should undertake steps to curtail the unfair use of non-compete agreements and other agreements used with employees. So that was sort of the launching point, if you will, for the FTC to formally take action. Now, that being said, as I mentioned before, there have been legislators on the federal level that have expressed concern about the use of non-competes, most notably Senators Warren, Coons, and Murphy. They wrote a letter to the FTC urging action in 2018. The FTC took it under advisement. In 2019, it had a workshop where it invited people to come forward from all walks, all perspectives, to provide their feedback and opinions on the use of non-compete agreements. The FTC issued a memorandum indicating sort of its skepticism about the use of non-competes, and then all havoc broke loose in January last year when the FTC issued a proposed rule in which it announced it was intending to ban non-competes and inviting public commentary. That announcement triggered, I think, 26,000 comments from employees, employers, academicians, lawyers that practice in this space, economists, trade organizations, et cetera. And the FTC took note of many of those comments and ultimately issued the rule we're going to talk about here momentarily. So let's talk a little bit about the final rule. We'll talk more than a little bit about the final rule. The rule was announced last Tuesday during the course of an open hearing in which the commissioners voted to first identify the rule publicly and then vote on whether the rule should be put in place. The vote broke down along party lines. The two Republican commissioners voted against it. The three Democratic appointees voted in favor of it. And it is now, as we'll talk about, the subject of litigation. One of the key questions that Chris and I were talking about before we got here is, when is it really going to take effect? The rule indicates that it will take effect 120 days from its publication in the Federal Register. And Chris, you and I were talking about, when is that going to be? And it's sort of a moving target. What did your research or analysis yield in that area?
Yeah, so it will happen when it happens, basically. No, what we would expect is that in about a week's time that gets done. It's somewhat an administrative function. There's no set deadline saying it has to happen within 2 days or 3 days. I imagine at the conclusion of a long period of time, there probably is some statutory requirement, administrative type code requirement, but I would expect here in the next 3 to 5 business days, we'll see it issued, and then that 120-day period will start.
Yep. So let's talk a little bit about the ban. First and foremost, it is going to operate retroactively and have nationwide impact. It will supplant any existing state laws or rules on non-competes, and it will affect all non-competes except existing non-competes of what the rule defines as senior executives. Senior executives are defined within the rule as someone who I think makes $151,164 per year, or at least annualized out to that amount, and has a policy-making decision. Within the rule, it is identified as examples, chief executive officers, presidents, or others who make policy, and sort of the circular type of definitional elements that you do see from time to time within this rule. But it will act retroactively, and it will displace any rules or statutes or laws as they relate to non-competes.
And John, just real quick on the executive
definition.
The senior executive definition. Yeah. I have a little bit more of the detail. Final authority to make policy decisions that control significant aspects. So it is a little unclear on who all is going to get pulled into this.
That's a really good point, because so many non-compete cases aren't just simply against sales representatives or against C-suite officers. They're against middle managers, if you will, or people that have had significant administrative experience within a large organization.
Right. So if you're in a closely held entity and you have a manager who has significant power under the operating agreement of the closely held entity, that manager probably fits within the purview of this exception, even though with the title of manager, he's not CEO, he's not COO, but he's acting like a COO most likely in this hypothetical entity that I'm describing.
That's a really good point. I hadn't really thought about the differences potentially between a large publicly traded organization and a smaller, closely held corporation. So again, some details that need to be flushed out or be worked out potentially in litigation. Any other thoughts on that definition? I didn't mean to cut you off.
No, that's fine. One thing that bears mentioning is that in terms of coming up with that $151,000 threshold, discretionary bonuses are excluded, right. Certain fringe benefits are excluded, with the idea being, what are you required to give that person? And that helps us figure out where do they really fit in terms of the chain at the organization. Yeah. How high up are they? But that, I think we can surmise roughly who's intended. There just is some ambiguity there in terms of when you see the word significant used. Obviously, that's not very precise.
No, not at all. And again, it's for existing non-competes. So with the passage of time, obviously, that is an exception that's going to be gradually phased out. Let's turn to the definition of what is a non-compete agreement under the final rule, and it differs somewhat from the definition that was supplied in the proposed rule. It's largely straightforward, with one exception. I'm showing a slide now that quotes the definition. And the portion that's probably going to be subject to some of the disputes or disagreements potentially is a term or condition of employment that, quote, functions to prevent a worker from competing. And in the proposed rule, there had been a lot of discussion of what was described as a de facto non-compete, and it singled out non-disclosure agreements in particular within the proposed rule as exemplars of agreements that could be abused. It was obviously something I was really concerned of as a trade secret lawyer, because non-disclosure agreements are probably one of the critical tools, if not the critical tool, in protecting trade secrets. So this what functions to prevent is going to be the critical language as it relates to other restrictive covenants or other employment agreements. So let's talk about some of those other agreements briefly. It appeared to me in reading the commentary, and it's in the commentary that accompanies the rule is, I think, over 560 pages. I can't say that I've committed it to memory yet, or got complete mastery of it, but I think I've got a good handle on really the key language that speaks to the intention of the FTC and what it thinks about the certain agreements. And again, this de facto notion was something that really caused a lot of concern for those of us that are enforcing non-competes or restrictive covenants from time to time. There do appear to be clearer statements this time about non-solicitation agreements and non-disclosure agreements being more safe to use on behalf of a business owner or a trade secret owner. And I've quoted some of the language here where the FTC acknowledges that narrowly drafted non-solicitation agreements and NDAs should survive scrutiny as not qualifying as these functional non-competes at the end of the day. Let's talk about some other agreements too that I think are of some concern. Garden leave provisions. Garden leave provisions are agreements where an employee remains on the payroll of an employer but is essentially sidelined. Maybe they've announced they're going to a competitor, or that they're a sales representative that you don't want working closely with key customers before they leave. You have the ability to give them garden leave. That is, let them go work in the garden while you compensate them over time, but they remain as employees. The FTC has okayed the use of garden leave provisions because you qualify as an employee still under the agreement and you're being compensated. By the same token, severance agreements that have non-compete agreements are problematic. The FTC has not given its imperator to severance agreements that may have a non-compete because the relationship's been severed, and under that definition, it qualifies as a non-compete. It's interesting because there's a subtle distinction between the two. There's compensation that's being provided to the employee, but it's really the termination of the employment that's critical.
Yeah, and the forfeiture agreements that you have listed, that's one that's going to have a big impact, yes. I think, especially on Wall Street. Heavy use of those type of agreements.
Yep.
Repay the training costs, and it's their way to kick you on the way out.
Yep.
So those being disallowed is pretty significant for big industry.
And for senior executives that might have stock options or other vested compensation that may take root later. Fixed term employment agreements, the FTC says it's fine to have non-competes during that term of the agreement, that's acceptable. Training repayment provisions, there's some disconnect there. Conceptually, the FTC does appear to be willing to allow them, but there's a lot of language there that says they'll be looked at very skeptically because of concerns about hitting somebody with $20,000, $30,000, $50,000 in repayment, and that having the effect of a sort of a penalty, if you will.
Yeah, if it's seen as punitive rather than compensatory, I think is kind of the key distinction.
I agree. Another interesting issue is who's really covered at the end of the day. Nonprofits, particularly in the healthcare context. The FTC expressed concern about hospitals or other not-for-profit entities being able to fall outside the non-compete law or rule, rather. And obviously healthcare has been a real hot area with the use of non-competes. The concerns about having physicians or nurse practitioners or other healthcare providers available in different regions, or being able to service meet the patient's choice has been a real concern. So that context is something that the FTC has not spoken on and has left a relatively vague test in terms of determining whether they'll be covered or not covered by the rule. So, well, let's talk about some of the exceptions that the FTC has recognized. The first one is a bona fide sale of business. That's another change in the proposed rule. The proposed rule had limited the sale of business non-competes to someone who could be a 25% owner or more. There's no such restriction this time. It's cleaner. I think it tracks the California rule, and as long as it's not a sham non-compete, if it accompanies the sale of a business where there's not insubstantial compensation, that'll be enforceable. Here's the one I think is really interesting, this good faith exception, and I think it'll really come into play with functional non-competes, because I don't know that if it's a straightforward non-compete, it is what it is. But if someone is enforcing a non-solicit, non-disclosure agreement, one of these other agreements that we've described, the FTC has given some wiggle room to someone that they won't be sanctioned for promulgating that rule, or promulgating that agreement, rather.
Yeah, I think it's going to be interesting in that area, assuming this rule goes into effect.
Yes.
The good faith exception, I also see it playing out in the area of, does this employee qualify as executive or not? Are they performing sufficient functions? And I think the bread and butter issue that we will see is that kind of manager type person that I was describing, that on the day in and day out basis, they actually do make those type of decisions.
Yeah.
And if they're above that compensation threshold, I think there's going to be reasonable disagreement. If the person doesn't want to be subject to the non-compete, they're going to say, I'm not a CEO, what are you talking about, right? But if you just look at the way they're operating within the business, there's a very strong argument that it would apply to them.
That's an excellent point. I hadn't thought about that context, yeah. And the final exceptions for existing causes of action. So if you had a non-compete that was enforceable before that time, before the enforcement of the rule, you should have the right to enforce it. So let's talk about the $63,000 question, Chris. The FTC's litigation, some of the other litigations that have been spawned in less than a week.
Yes, so right on time, right after the rules announced, the U.S. Chamber of Commerce, along with local Chamber of Commerce, Business Roundtable Group, filed litigation in Eastern District of Texas to challenge the rule and the rulemaking authority of the FTC, and this is a surprise to no one. It was announced before the rule was ever finalized that they would be challenging the rule. When the proposed rulemaking was announced a year ago, we all started putting our pens to paper and analyzing whether the FTC even had authority to do this, and many of us believe that they do not. I am one of them. And so we see this litigation. We've looked at the complaint. We've also got a copy of the motion for preliminary injunction that's already been filed. Just in terms of timeline of that, it's likely that there's going to be a decision at the end of June or in July. The motion for preliminary injunction, I think, is going to be fully briefed by the end of May, and then there's going to be a hearing on it. The big thing that the U.S. Chamber of Commerce is saying in their papers is that there's no indication anywhere that it was intended for the FTC to have rulemaking authority. When a governmental agency is intended to have rulemaking authority, there's a very specific delegation of that authority, typically. The FTC has pointed to a half clause in this provision that mentions rules to carry out part of their duties as somehow intending to grant them broad rulemaking authority, which again is the subject of spirited debate, separate from the legal arguments and the fact that there is no precedent over the last 150 years for the FTC to have any involvement with these state-by-state governed non-competes. I'm looking at the venue where this case is filed, Eastern District of Texas. This is the same venue where the proposed final rule by the Department of Labor was struck down and stayed back in 2016. Reading the tea leaves, to me, it seems extremely likely that the rule is going to get stayed by this court. We can obviously not say that for sure. We got to watch and wait, and we all got to, make sure that we're staying on top of it, which we obviously will be doing.
Yeah, yeah. I mean, it's amazing the amount of interest that litigation has is generated. Well, that's a good segue into talking about what employers and trade secret owners and business owners should be doing right now in light of the FTC rule. Pull up the slide here. Point number one is sort of, you could sense the skepticism on this seminar by Chris and I. We're admittedly advocates, maybe a little bit biased, but it's something we've looked at, and we're not alone in terms of the commentators that I follow and respect, thinking it's going to be a very heavy lift for the FTC to ultimately have this rule not disturbed.
Yes, right.
Right.
We are not alone in that regard. And so the question for the business owners, folks that are tuning in, or even if they're not tuning in, is what do we do? And in some ways, I would say we go back to the things that we've been talking about ever since the Jimmy John's case and this slow trickle of increased regulation, right?
Yeah, and judicial skepticism.
Right.
Yeah.
Right, and for me, the biggest thing is taking a deep look at your business and figuring out what is the thing you're really trying to protect, and then having those conversations with counsel and going through the process of employing the other tools in the toolbox to get there, and not relying strictly on non-competes. Because why do we have the non-compete? It's because if that person goes over to the competitor, they know so much about your business that it's impossible for them to not improperly compete against you, right? Yeah. But so what is it that they know? How do we protect it? Let's use the restrictive covenants in our toolbox. And in the meantime, so then we're less reliant upon the non-competes. But I think the biggest unfortunate thing, John, is they announce this rule, the FTC does, and then it just creates so much uncertainty for business owners, right, and folks across the country. There's so much confusion that's frankly entirely unnecessary and avoidable.
Yeah. Well, and to your point, I mean, I think most people have, we've been talking about the forces that are going on at the state and federal level. And judges are not immune from those pressures, from those issues. And you are seeing decisions increasingly where courts are expressing skepticism on the facts of that particular dispute about enforcing a non-compete. So it's always been good practice to make sure your agreements are narrow and protecting the legitimate business interests, the trade secrets, the business relationships that you've talked about. So good hygiene with your agreements is always to be encouraged. The other thing I think that it's important as a takeaway is if you've made the decision you don't want to have a non-compete, if you've made the decision, I just don't want to be bothered with the aggravation, with the litigation and the uncertainty, it does look like the FTC's provided you with a pretty clear path in terms of a non-solicit, non-disclosure agreement. They provided some detail about the types of carve-outs in the non-disclosure agreement that will immunize that non-disclosure agreement from being found to be a functional non-compete. So that's available to you too if you want to have that. Narrowly enforcing it, being careful in your litigation, particularly now with all of this swirling around you, it's a good time to think reasonably in terms of what you go in for.
Absolutely. Even assuming that the FTC rule gets thrown out, never goes into effect, and we continue down the path that we've been going down, if you are in a climate where you go after a low-wage worker who doesn't know anything special about your company, then that contributes to the skepticism in the air about enforcing non-competes.
Yeah. So I guess to sum it up, sit tight, wait to see what happens in Texas and in eastern Pennsylvania and Dallas as well. Be judicious in the way you use your agreements. Take a second look at them, make sure that they're sufficiently narrow, and you should be fine over the coming months.
Yeah, absolutely. And I'm sure as soon as there is a ruling on the litigation, John and I will figure out a way to be talking about it.
We will. We won't hesitate to share our thoughts on that. Well, it doesn't sound like there's any questions, so thanks for joining us this afternoon, and we'll look forward to having another seminar perhaps when we hear from any one of the courts.
Absolutely.
All right. Thank you.